Welcome to GOLT TALK, your podcast for technology and innovation in the legal profession. If you're searching for solutions to revolutionize your legal practice, you're in the right place. 10 minutes pure, actionable product insights from CEOs shaping the future of legal technology. And here is your host, Tom Pfennig.
Welcome to GOLT TALK, your podcast for innovation in the legal and compliance space. My name is Tom, I'm your host, and I am thrilled to welcome a special guest at this special episode who will tell you who he is and what he does. Cyrus Johnson in Texas, and I think this is a unique episode, Cyrus. Please tell the audience who I have in front of us.
Here I am, Cyrus Johnson. I've been in law since last century, Tom. Law school at the University of San Francisco and early practice in the Silicon Valley, San Francisco. I got sucked into the wave, headed towards India in 2004. We built what people understand today as institutional. It's not even BPO anymore, business process outsourcing. It's embedded. The story arc over the course of 25 years, I've been selling software, technology, buying software and software services for clients, Fortune 500. We've been investing in India and watching this rise till we get to the COVID era, changes the whole world, makes everything virtualized, and into the virtualization era steps artificial intelligence. So I fell in love completely all at once in 2022. I said, this is not an additive to law. This is a constitutive. This is the way to law. AI will not add to law. AI will be law. So I committed my career, a large portion of it. I'm still walking two planks, Tom, between practicing and helping clients and developing AI tools for the future of law.
Very good. Welcome again to GOLT TALK, and we are going to dive right in with 6 very different questions from what we normally ask legal tech CEOs, because this one is going to be much broader than introducing a tool, introducing competitors to that tool, introducing implementation efforts. We are really going to talk about the lay of the land of the legal AI world right now. All right, let's dive right in, Cyrus, and I am going to take the liberty to leverage some of the 20 questions that you put out on your Substack channel just, I guess, a week ago, which I found intriguing and very informative. And you and I agreed ahead of this recording that we would be focusing on these 6 areas. But before we get there, I wanted to re-emphasize that this is really an interesting combination of your world, which is largely centered around the United States, Canada, I guess, and maybe also South America. My space certainly cuts into yours to some degree, but I'm occupying Europe, Middle East, and also Asia Pacific, as Transforming.Legal is also a Singapore-based company. I've been to China, try to build this bridge, you and I, amongst all these different jurisdictions. So we hope there is many viewers around the world finding the two of us informative and perhaps also a little bit entertaining. So with that, the first question that I am going to pick is the following. If, and let's call Huawei out or Legora or others, if these tools compress between 30 or 60% or more of repeatable legal work, where does the economic value go? So I think this question is coming up at every conference, on every panel. If there is a significant efficiency gain, obviously some people need to benefit from this commercially. And the question obviously is who? So I'll throw this over to you. What's your thought on it?
Well, I always go back to first principles, Tom, and ontology. And what are things, right? What is a lawyer and what is the work of a lawyer? So I think it's important to disconnect, a deconstruct. Okay, you mentioned on one of your recent videos that I saw, which was great, about the role of a lawyer. So humans, we are rote creatures. We look for tools and we use tools. I would say much of the conversation around AI and law talks about work as if it's a perfectly fungible item, that AI right now will do 100% of the work of a lawyer. That's what we're all been talking about, robot lawyers. However, there's really 5, and I speak as a practitioner, there's 5 dimensions to the lawyer. Only one of those dimensions is the actual, work, editing documents, drafting, analysis, arguing. The others are something I think you mentioned, the prestige factor, that someone hires a lawyer so they have someone who has their back. Very often, they're going to get someone who has a name, right? Certainly on the higher end of the investment scale. We want someone who's known. So the prestige and backup of the lawyer. The other element that AI will not remove is something embedded in law itself, is the liability protection. And what I don't mean is the lawyer will keep you safe from liability. I mean, functionally, the purpose of the lawyer is that third party who speaks on your behalf. And what that means is when that person speaks on your behalf, the client has the ability to always step away from it. Oh, my lawyer was wrong. He misspoke. So you've got to pivot in the middle of a law practice. AI doesn't capture that. The fourth would be what I call juice, right? Which would be a New Jersey style expression, juice or power. The lawyer has influence. The lawyer can command change. The AI is not able to do that right now. And then the 5th dimension of the lawyer, of course, is the relationships. We can talk about doing law on our computers by ourselves, and this is a point you made as well, lacking the relationships with others, be they judges, opposing counsel, company leaders, you're going to be hard-pressed to get your initiative across the line. So I guess my upshot would be in Harvey, Lagora, and the thousands of other rappers out there, when they compress the work, they're compressing that first component only. And most of the lay people don't know that. However, most of the lawyers do know that. So there is a wealth of opportunity. I would say 80% of the market for law is untapped, untouched, as we human beings look for this black box tool that's going to fix everything.
So translating what I am hearing, and I'm going to jump in with yet another slightly different perspective, is that out of a cake with 5 pieces, there's only one slice that is impacted by AI, and that slice could be compressed 99%. But the 4 other slices of the cake, as you've just alluded to, they cannot be made obsolete. They cannot be substituted by AI. They will remain valuable to clients, and clients will remain paying for these 4 slides. Is this your economic module, essentially, that you foresee?
Similar, if we take that cake slice metaphor, I would say the slices, Tom, are fungible and each of them determinative. So if one knows the right lawyer, I have clients come to me and say, we're going to sue this person, major company. Look what they did to us. We're going to sue them. My mind goes off. I say, wait a minute. I think I know the right phone call to make to the right person. I think I know what I should say. One phone call, the matter gets resolved. So if that's one of your cake slices, call it experience or influence. Any one of the cake slices can do it. And 5 of the cake slices are available for augmentation with AI. And yet 90% of the market for AI for law focuses on one of the 5 cake slices.
I love that. I think I have not heard this analogy before, so we might be quoted on this at some point, Cyrus.
Let's continue to make news, Tom.
Let's continue to make news. Here's my take on this, and I try to augment what you're saying. First, I read somewhere that the VC pitch of a Harvey, for example, is our tool is increasing productivity of a lawyer 10x, 10 times. And there is no qualification. We basically improve the effectiveness of a lawyer 1000%, which would technically mean with a Harvey license, you substitute 9 lawyers. This is, in my view, translation of that line, increasing productivity 10 times. I think there is a significant misconception in this perspective. And of course, it sells very well. But adding to what you said, you're not going to be able to improve trust 10 times, for example, or active listening skills, or seniority and pragmatism to resolve something on the phone. So that connotation, to me, as enticing and as spectacular it sounds, in my view, is subject to a reality check, first of all. Secondly, it's not just the lawyer we are talking about, it's the client as well. And many clients, both in-house and outside, served by law firms, are just not digital people. They just don't want to pull a ticket or, use a self-service tool to find the answer. They are afraid that they find a wrong answer and ultimately get hammered by a judge. So they want your face, my face, a lawyer, qualified, having been in the trenches, to basically give them this answer and also a back to hide behind in order to win the case or defend someone properly. So this whole idea that this market is a digital market where software is going to hit like a rock is, what I am seeing, not the case. So product market fit, I have been vocal on this in my channels, is a challenge, and is a challenge that remains to be for the next several years, because both sides of that legal market, the clients and the lawyers themselves, are happy with a fairly traditional way of working. And I think there is some value to this traditional way of working, as we've just alluded to. So long story, the economic value is more limited than I think the market is thinking, and hence the savings that are projected are just much smaller right now than what we are really seeing on the bills. I believe there is an expectation on in-house general counsel's side that is not going to be met over a short to mid period of time, because this trust, this defense shield, this knowledge protector or guardian is worth a fortune if you are in a better company situation, if you need to defend your license to operate, and if this has to be fast. So I think this is a very comprehensive answer that we have given on your first question.
There's more that can always be said, right?
Yeah, for a podcast, I think we are kind of raising the bar in terms of substance quite a bit, and novelty of perspectives as well. So let's move on to your second question. The second question is kind of the 400-pound gorilla in the room, the billable hour. And it goes like, does AI accelerate the death of the billable hour or reinforce the concept of the billable hour? You go first.
Death, period.
How come?
Full stop.
How come?
If we think about the economics of law, if we think about the economics of law firms, and I know you're well aware, as I am, of large firm billing, again, not billing models, zooming back from legal work, mega trends, financial models. We have 50 years of law firms which are built on commitments, right? No one talks about it in AI. Well, I do. No one talks about it in AI. The large law firm will be levered, as we call it in investments. It will have debt, right? Substantial debt piece year to year. It will have commercial real estate, either directly held or through a REIT, or debt service upon some commercial real estate. What we've seen since the pandemic, at least in America and much of Europe, and less the case in Asia, is the wholesale collapse of our metro corridors. What do I mean by that? You're seeing mass, what do you want to call them, defections from the public square. The pandemic, the COVID pandemic, was not a drill. It was not a phase. We are not post-COVID right now. It was a fundamental reordering of how society is structured. So, meaning, we have vacancy rates in Chicago, Los Angeles, New York, right? Other metros like where I am in Dallas doing well, doing better. Florida doing very well. But you're seeing collapse in New York, collapse in Chicago, collapse in San Francisco, collapse in Los Angeles. What that means for the law firm is a good portion, a goodly portion of their economic model, right? And their obligations that they're required to service the debt on. We're aware of the rate environment over the last couple years of very steeply raising interest rates. That means the bill to the law firm up for their debt service, whether it's their real estate component or just their flat, equity. The debt is built on future revenues. Lawyers and law firms are no dummies. We do the best economics of everyone, like your major corporation. We have projections for next quarter, next year, 5 years, 10 years, and it has all been built on the amount that can be extracted from clients. These are projections, okay? These are estimates. The estimates are quantified by the billable hour. That's a fact. Here comes AI into the space. I'm very skeptical, as you know, of LLMs. And I think we're in the middle of a LLM market collapse, a distrust. I'm always selling outside of LLM bespoke AI. I believe it's the future, P2P, open source AI. With the LLM collapse in trust among law, right? In belief that it's going to always give me the right answer, because lawyers don't 80% need the right answer. We cannot introduce 20% doubt. We cannot introduce 10% doubt. We cannot introduce 2% doubt into our analysis. So you're seeing an LLM as a tool collapse in law to a certain extent. At the same time, Tom, those who are more sophisticated, will derive more from the LLM than those who are less sophisticated. I'm almost done here, doing this thought train of analysis. If you take a corporate, anyone, Caterpillar, Charles Schwab, Bayer, you name it, you take the CFO of that company. The CFO of the company is going to use your ChatGPT or your Gemini or your Harvey. Let's say that many non-law users of Harvey. Corporate CFO is going to be able to prompt properly, and he's going to be able to read what is true from what is untrue based on his sophistication and experience. Under these pressures, rate environment, commercial real estate problems and collapse, there are other events. We haven't even talked about the war. We haven't talked about crude going up 20% in the last week, Tom. Crude oil, 20% 1 week up. Companies will have to do more with less. And a sophisticated party at a formerly corporate client will be able to do it himself now. What does that mean to the large law firm? Well, they can project forward that Procter & Gamble is going to pay them X billable hours, but you tell me it's just unreasonable to expect that the billable hours survives under this environment.
So as we want to have this a bit provocative and obviously entertaining as well, I would add a slightly different nuance. One, change is uncomfortable in many respects. So the billable hour is an animal that has been around for many decades. If you change it, you are disrupting what you know. And there is the saying, as you know, better the devil you know. So the billable hour is the better devil, because the alternative is a bit of a black box as well. Who can properly project alternative legal service fees, for example? Who can, I think on the law firm side, also have transparency towards the client when you wrap a number around a fairly complex topic? And with the impact on the leverage model, you're gonna have still several layers of paralegals, lawyers, senior lawyers involved. I, as a general counsel, may want to see who you are involving, and I want to see, even if it's a flat rate, how you calculated that flat rate originally. So while I agree with you, it is a logical projection that this antiquated thing is going to go away. The beauty of this antiquated thing is the better the devil, I know. So that to me is going to stick around, at least for the big law firms that have a slight monopoly on their knowledge superiority, on their relationships with governments, on the track record in the trials, for example. And GCs don't want to fuzz around with these big, heavy things. They are, as you said, challenged with many new things, tariffs, supply chain disruptions, whatever. Do you want to start yet another corporate war with the billable hour coming under the bus. I don't see this yet. It's partially happening in the tier 2 segment. It's partially happening in the smaller law firms. But when it comes to big law and complex matters and bet the company matters, I still think there is some benefit to the good old model. How it's being calculated. Is it going to go down or is it going to go exponentially up? I think it's going to go up, frankly, because there is a scarcity of these top talents, a scarcity of the top names, and you need to know people in the government. You need to know, have a good relationship to the judge or to the regulators. And these people cannot be substituted by AI. So therefore, their value increases. And I would say I am still a billable hour guy if I am one of these top experts, because finally you talked about prestige. The billable hour is a prestige model. It's a very interesting KPI. How much am I worth in this market? And do you think those who have been building a practice for 20, 30 years that are now commanding $3,000 an hour proudly want to give this up for a undetermined kind of generic value? I doubt that. But here we are, and subject to another podcast, I would say.
Well, I think, it's a truism that the lawyer is going to make his money, period, full stop. I see a direct analog. There's an analog for this. It's happened already, Tom. You lived it. I think I lived it. I think you lived it. When you talk about investment process, year in, year out, and we talk about audited financials, okay? I've been in this business since, like I said, last century. When you're presenting audited financials on a certain level of the market, right? On a certain level of the market demands, I need a Big Four on that. I need a PwC, okay? I need a KPMG. And you come with a lower brand accounting firm, and there are many large investors who won't look at the deal unless it's audited by Big Four. I think we see the same phenomenon taking place in real time right now. The lawyer's going to make his money. The lawyer has the relationship with whatever you want to call it, the corporate offices globally, and he'll say, look, we need to do XYZ this year. What will you give me for it? What can you do for it? I've seen these deals. I have done these deals in law before AI. And parties understand that they're in a joint undertaking. They both have needs. And so maybe I'm overestimating. I'm certainly probably for you overestimating numerically. These aren't the 80% of the deals. These aren't the 80% of the deals, but what I'm talking about is the 80% of the capital deals. Most certainly, I'm hearing from practitioners and I am seeing myself. I can give one vignette about a client matter. And I said, I'll do XYZ flat. And we do the thing over weeks. And then the client was wedded to the billable hour. Just give me your time. Just give us all we want all your time. Just give us all your time. Here's all my time.
Interesting.
Here's my rate. Do you know what the reaction was, Tom?
No.
Wow, look at this big bill. They asked for all my time. I provided all my time without revealing any client confidences. The communication was that the bill, the metric, the hours plus the rate were too high, and we opted to pivot to the original flat fee that had been suggested. Everyone is going to be in a savings mode, Tom, whether you know this well, whether they're top of the market, bottom of the market, under pressure, high revenue. Businesses succeed by maximizing, and AI is a credible excuse. We have Big Four accounting doing law now, Tom. We have Big Four accounting with a law license in the state of Arizona. Big Four accounting firm.
We know. Hey, let's move to the next question. What happens to leverage and talent models in big law with AI? So I'll kick this out very quickly. This is not necessarily my turf, even though I was at the law firm decades ago. I still think, as I ventured to say, the billable hour is not dead yet and anytime soon, that this model is going to stick around for some time as well. Otherwise, what's the alternative? Nobody has one yet. So without a credible business model as an option to dismantle your current one, people are going to stick to what they have, is my prediction. And of course, maybe entry-level salaries will go down. I would also say this is a ring-fenced business. This is a ring-fenced cohort or community. And you want to bring the smartest law school graduates into your firm still, with or without AI, because they might be the superstars in 2050, charging $50,000 per hour. So you want them in your shop now, and there is always someone who's bidding against you, raising the price. So long story short, from my point of view, the leverage model is going to stay unless there is someone on the big four scale that finds an alternative. But as this is going to be significantly different and therefore significantly disruptive, I have my doubt that we will see this within the next 2 to 3 years.
The star lawyers of tomorrow are young right now. It's a fact. In the United States, something like 50% of the lawyers are age 50 or over. Okay, what we're seeing is a decline in raw numbers of lawyers in the United States. There are other jurisdictions that are growing, and I should say the United States is only the 5th country per capita number of lawyers. Number 1 is Israel, but USA number 5, and the charting that I've done shows, and it's a contrarian position. It's a hard pill to take. We are going to see the first ever decline pullback in the number of per capita lawyers in the United States. Okay, based on the baby boomer phenomenon. Okay, the deaths of baby boomers over the next 10 years is going to keep the number of lawyers per capita stabilized. Okay, outside of 10 years, 2037 and onward, my charting indicates that we're seeing first ever decline in the raw number of lawyers per capita. What does this mean? Right?
What does this mean? And I think a number of people might not be disappointed or sad. So let me hear, what does it mean from your point of view?
Shakespeare, Henry VI, the first thing we do is kill all the lawyers. I put that on X at one point, Tom, and I got flagged and banned for putting Shakespeare. And I put the quotes, Henry VI, stanza, quote, first thing we do, kill all the lawyers. Many people won't mourn having less lawyers, but the lawyers left behind will have more work to do. And how will they do that work? We're already doing it differently now. There's something that we have an analog for in the past, which was the entry into the market of, say, LexisNexis, right? And Westlaw, transformative. And, I did some work for Lexis in the late 1900s. Talk about old. In the late 1900s, did some work for Lexis. Okay, go back 20 years before that. Go back 10 years before that, Tom. 10 years before that, we have less than 50% of law firms using computer native. Okay? Go back 10 years before that. And I know some older lawyers from when I was younger, and some are still around. The real lawyer is in the law library. Get down to the stacks. If you're not in the stacks, you're not our kind of lawyer. So if you think about how archaic it is.
Yes.
Read Elsevier and coming in, capturing the law as data, capturing the research, real-time case updates, citations that aren't made up like LLMs. It's a skill to learn. So we had the 80s, 90s into early 2000s. We had very experienced lawyers, celebrity, super lawyers, what you would consider. Many did not use email. Many did not do legal research. I'm sorry, scandal, breaking news. People get so twisted out of their minds, Tom, about so-called fake case citations.
Yes.
This guy went to court and the judge busted him. And maybe the lawyer is 75 years of age. People outside of the law think that lawyer typed the paper and gave it to the court and then went and argued it. That's not how the law is structured, certainly in the West. Including, let's say, the British legal tradition to this day, right? Talk about Europe, the barrister and the solicitor. The solicitor is the lawyer who prepares the papers. The barrister is who argues before the bar. Okay, Tom, you know full well which one of those I fit into. If a client wants to mess me up, ask me to draft something. So you have lawyers bifurcated into paper lawyers and verbal lawyers. And so that took us through the 80s, 90s. These lawyers aren't doing legal research. Now, today, 2026, March 6th, anything that's in law can be found with AI, including things that do not exist, right?
Let me jump in quickly, Cyrus, because I find a lot of stuff about a law or a case or whatever, but I think without having gone through the trenches and through the hurdles that you and I went through during our law studies, I'm not able to find out what I'm reading is the truth or is fake law. So you still need to have the traditional legal education to separate fake law from real law. And as there is always going to be hallucinations, and you just said there are areas in law where you want 100% precision and people want human in the loop. Regulators want human in the loop. Clients want human in the loop. I think there is going to be still a need for a traditional legal education peppered with access to legal tech and understanding what it can do. And given that universities will still produce these people for the next half a decade at least, because you would also need to change the regulations for legal education, which is a completely separate topic, you will have a market for these people. So our topic number 3, if I hear you, is similar to what I'm saying. Even though we come from 2 different angles, there is going to be leverage still. There is going to be young top talent that is going to have strong marketability, market pull. So the talent model in big law, the leverage in big law will largely remain as is for the time being, because you need these lower entry-level associate layers. And I think also from a commercial model, you need to build these lower-level associate layers in order to have the profits on the top.
If you go to my Substack, you'll see I have a model of the law firm, and the old looks like a pyramid. Okay, that took us to 2024. The new model I see is an inverted pyramid. Okay, you're going to have people owning law firms needing less staff to get their things done. At the same time, you're going to have multiples on the lower, call it the software layer for law. When a very sharp associate who's 5 years out figures they can win, and they will be able to win, and I saw them win, we're into a whole new model. So the work of the lawyer is changing fundamentally. The new lawyer is very young right now because they're going to be best tuned in manipulating data structures to get to the answer. I can tell one quick vignette. Going back to the pandemic again, and I had a matter in which we had super lawyers. They're now, I saw the article you mentioned, 3,300 an hour, and I see that as, grabbing the potatoes before the doors close. I see that as we're not going to see $5,000 an hour. We're not going to see $4,000 an hour. They're grabbing the potatoes before the doors close. But super lawyers representing my clients in a case, litigators, initiating the case in 2018, pandemic hitting in 2020, hearings on Zoom in 2021, and I see and experience super lawyer. Here's a demonstration. Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. What am I saying, Tom? The skill set to achieve in litigation in 2020 became the ability to use frame your background, look persuasive, look appealing. The super lawyer class didn't have that. They spent 50 years perfecting physicality. How do I stand? I do an eyebrow. One super lawyer does an eyebrow to the judge at the right time, and they win. That's gone. That's gone. It exists in a 5% reality in the top litigation sphere, but the 95% of the reality, we're appearing on Zoom. We're having our meetings on Zoom. I don't care if you're 50 years super lawyer. If your setup looks like crap and you look like crap, it's not gonna, go. And I'm speaking now in the hypothetical.
I'll throw a little bit of a monkey wrench at you. I think it worked in the pandemic very well. For whatever reason, we went back to pre-pandemic appearances, unless you are in China or other parts of the world where it's really massive to see the online dispute resolution industry growing in more saturated Western societies and jurisdictions. I think the willingness and appetite to go into those digital routes, as much as you and I are at the forefront of innovation in this profession, is just not there yet. As you said, the average age in the US is above 50. We have been drinking the Kool-Aid for many, many years. We kind of run the show. We run the regulations. The judges are part of this mix. So the moment you start changing it, this group of people will feel uncomfortable. And unless there is an external force pressuring you to change it, we go with the flow, and we'll see not that much digitalization into traditional legal environment in the Western societies.
I have your external force.
Regulators. Tell me, who? Politicians? Clients?
No. Money. An in-person court appearance is 3 bills. An in-person court appearance is 3 bills, and I know this from experience. You have the time in court. You have the time of transit to court. And you have the time of returning from court. And you may have a 4th bill for the preparation for court. You talk to this mythical CEO, CFO that we're thinking about, who's got to make his quarter, who's going to approve the bills for legal. And one of them offers 4 bills, and one of them offers celebrity software. Harvey.
I disagree, because the infrastructure is just not serving that celebrity software. There are no real online courts in the United States. There are no online judges in the United States. There are no digital filing repositories in the US or here in Germany. So the infrastructure is just not yet serving this beautiful vision. I'm sorry, we are dreaming, we are daydreaming, and I love it. But I see the reality, Cyrus. I see the people running reality. And of course, we all love great movies. We are watching a movie right now, not reality.
So I just say my courts are digital native, digital preferred. Remote appearance is, compared to 20 years ago, remote appearance has become more than customary. It doesn't mean people don't physically go there.
Cyrus, in big litigation, I have not seen it. In big mass torts during pandemic, yes. But
the bulk of a case for your status conferences, which form the bulk of the billings for a case. Sure, yeah, it's done electronically.
I just wanted to make this point clear. The real case itself is not adjudicated online. These are pre-filings, these are mediations, they are maybe a group settlement conversations, MDLs. The actual war is still in the courtroom.
That's true, but what percentage of cases go to trial in the civil and criminal unit?
Cyrus, I think those where you make big money as a trial firm, not those that are resolved online.
Right, so we're talking about a bell curve. We're talking about on the high end what you're talking about, and I think we don't disagree. We're talking about the 5% of elite litigation, global litigation, and then we're talking about lower market. But I see a bell curve.
And I think, Cyrus, we talk about different jurisdictions as well. You know, you are in a very innovative jurisdiction in the United States, which is really enticing a lot of commercial players to come in. You have Tesla and the others. So I think you are attracting a certain group of investors and entrepreneurs with that legal system. Is it representative for a large part of the United States? I don't think so, actually.
I'm saying that, at least with corporate entities, major corporate entities, and I would say in the middle of the market as well, companies spend more money on legal to not sue than to litigate. Companies spend more legal to avoid, avert, settle, mediate, restructure, right? Restructure is corporate, in my wheelhouse. We'll change it. They're suing here, we'll change it. But that's 80% of it is not suing. 20%, again, Pareto rule, 20%, okay, suing. And I won't disagree with you there. There's tons of money to be had. And the super lawyers, discount them, I'll just say finally, not to discount them, ours did a phenomenal job, and they will become more elite. No one is putting them out to pasture, if that's the thought. Their celebrity status, their cachet, their marketability is going way up as AI rises.
Yep. Let's move on, because we want to cover at least 2 more areas. We can combine them. Number 4 and 5 on your list, Cyrus. When does AI move from assistant to co-counsel? And if every major law firm has one of the big legal AI tech tools, how do they differentiate? So this is another very interesting topic in terms of differentiation when everybody is fast and furious and smart as hell because of proprietary legal tech tools. And if, as you project, there is a true co-counsel, so substitution to a lawyer in place, how, if everybody does it, is it really differentiable? So what's your take on it?
There's the way that it is, and then there's the way that I project it to be, okay? So speculation, trend spotting. We look at Harvey right now, it is a celebrity software, right? It is the top of the market. It is the 800-pound gorilla, as the expression goes in the West. It is very good. It is very effective. And I should say it is being used not just by legal, but by accounting to do legal. Many people don't realize that accounting is also legal. If you're selling AI, if you sell it to an accounting firm, you in essence have 2, maybe not 2 transactions, but 2 categoricals, 2 buyer groups, it should say, between F&A, finance and accounting, and tax and audit. Tax and audit is much of it is legal. So selling to accounting gives you 2 customers. Selling to legal gives you 1 customers. I believe where we are right now, we're reaching a saturation point because we are trying to, I made this post, put new wine into old wine skins. Okay? We're trying to take something which is utterly transformative to law, qua law, which is AI, which is the reordering of all our data, which is law. So something fundamental, something transformative is being applied to something finite, fixed, bounded. Like you said, billable hour, it presents a problem. It presents that problem for that lawyer, which is, if I can draft a contract in 10 minutes that took me 5 years ago, 3 hours, where does that deficit, the delta between the time expended by the lawyer and the amount that I would like to bill for it, where does that go? Who does that belong to? Big law has this question, and in a sense, Harvey has posited the question. And the question is not solved yet. But what we are seeing is increased adoption by law of AI tools. And I've built them to take tasks, to take files, to take, a 5,000 record case file, Tom, which would have taken 3 and 5 assistants 2 weeks in a conference room to review. I can parse that in under an hour now. There's a problem between what the law firms must earn, have earned, and the way the work is being reordered. You can do 6 in an hour. You can do 10 in an hour. So that question must be answered. My answer projecting forward is we don't remove the lawyer from the equation. We don't say that AI, black box AI, the magical oracle, right? AGI and all these fictions. AGI is fiction, by the way. AGI is not real. AGI is theoretical, and AGI will not happen because man is constantly changing. Human knowledge is constantly changing, ecosecond by ecosecond. So we'll never get to AGI. But Tom, what we can get to is specific discipline areas, total intelligence, digitization of law. But what it requires is taking that personality, that lawyer, instead of the lawyer using a tool that's sold to him or her, the lawyer becomes the tool. The tool becomes a digital expression of that lawyer. That is in the interest of that lawyer. It is in the interest of expanding revenue rather than shrinking revenue. It is in the interest of the community who seeks legal. There will be more instant information that is expert, not generalized LLM, expert, vetted over years. So the digitization of the lawyer into a product, into a tool, is the future.
You're already foregoing topic number 5 here. So I think this is entering the final phase of our interview. But just to wrap up the answer that I am hearing on those two questions that we've combined, will AI move from assistant to true co-counsel? And if basically every major firm has something like RV, how do they differentiate? I think the point that you are making is AI will never really be a true co-counsel or a substitute to a top-notch, active listening, empathetic lawyer, nor will every law firm just be defined or determined by the way it uses legal AI. There's much more to the package. There is the human aspect, there is the trust aspect, there is the pricing aspect to it as well. So I think the idea that there is going to be parity with respect to legal AI deployment and utilization is not going to happen. So we'll always have more AI-driven law firms. Others might be more human-driven. And there's always a market, in my view, for different offerings like that. But you said, and this is kind of our closing, what you see is the lawyer/the law firm of the future. And I really don't want to talk about 2030. I want to talk about 27, maybe 28. So what do you think? I think we have a bit of a different trajectory projected. Yours is a bit more furious than mine. So predict 27, 28. Will we have this augmented AI lawyer which really has the machine next to him or her and is pulling it wherever in order to accelerate and maybe even improve the quality of the offering? Or will it still largely be human-driven?
AI is human. AI is a digital expression of human knowledge. I call it digital mimesis, okay? For those readers of Rene Girard. It's part philosophy.
What is it? Digital
mimesis.
What? Digital?
Digital mimesis. M-I-M-E-S-I-S. There's a French philosopher named Rene Girard who expressed the human condition in terms of something he called mimesis. And that basic idea is that human beings learn and form their behavior based on, to put it simply, mimicry of the things they see around them.
Yes.
The conversation with an AI chatbot tool is it's a window into human thought. It is I say AI is human. It's a digital expression of the ideas of mankind. In law, it's the same. What big box AI has tried now is to say, we're going to put that in a box and we're going to sell you $1,200 an hour per seat, Mr. Lawyer or Mr. Accounting Firm. Going back to the roots of what AI is, what law is, we have human lawyers with ultimately human clients. Sure, corporate clients, but humans for corporate clients. So where do we go in 2027? Well, I believe we go where I've been going since 2023. Only, Tom, here's the catch. Much of it you won't see. You're not going to see it at all. We have the attorney-client privilege, right? There's been some press about it here in the States. New York Judge Rakoff, who was the judge who sentenced Bernie Madoff, but he ruled, he made a ruling, the first AI ruling, that AI search is not privileged and it is not attorney work product. Privilege means, may not be revealed.
Yes.
Lawyer can go to jail. Work product, as we know, is a different category. It means it's presumed confidential. You have a New York court ruling saying AI is neither privileged nor attorney work product. But where many online begin to scream like sheep and say, AI is not privileged, AI is not privileged. Experienced lawyers like yourself and myself recognize what that is. Oh, someone has just written us a guide. Someone has just put elements on a page. I can use those elements to serve my client. So the future of AI in law is human, local, expert, bespoke, and privileged, Tom. That's why we're not see a lot of the development. And what I did in 23 was to create a bespoke law bot for a client of their file, of the thing that's got them up at 3 a.m, worried that they can chat with anytime, Saturday, Sunday, Monday. I created the bot. So therefore, I don't understand what the bot is telling me, Cyrus. Ring, ring, text, more often than not. Again, erosion of the billable model. I'll get a text. I don't get, what was this date? What was that thing? And then we orient with the client. So creating bespoke tools, which are privileged, meaning we're not going to see a lot of them. And it is happening now. And I understand Harvey is doing some of it. But this is the future of AI in law because it's expert instead of generalized as one would derive from an LLM.
Yeah. I think what this also shows is that this idea of process synchronization, harmonization, automation, elimination is one slice to the cake. As we started earlier, it's not the whole cake. So there is 4 slices of this cake yet to be discovered for AI in a completely different way than it's currently presented to us. And I think, Cyrus, a conversation like this, and we are entering almost the full hour, is only possible if you bring 2 people together who really understand the legal profession. From the old days, as you and I think, have been in the 90s to the 2020s, but you have to be realistic. You have to understand the cohort, the lawyers, the profession is different. The expectation to this profession is different. And the application of AI in this profession will therefore also be very different to what we are seeing in other industries.
Not an additive, a constitutive. AI will not add to law. AI is law now.
I think the dialogue is valuable for all of them because we are injecting sobriety and we are injecting still innovation, and that's the cool combination. So with that, Cyrus, thank you so much. Having been on this podcast, there has been a lot that we touched that I have not seen anywhere else. Let's perhaps, depending upon how the audience reacts to us, set up another window. You and I will have our eyes and ears up all over the world, US, Europe, Asia, and we will follow along the expected changes as well as the unexpected static situations that will still are going to be out there. So happy Friday. Have a great weekend. It's been an absolute pleasure talking to someone who has been in the trenches and is redesigning them. Take care, Cyrus.
The privilege is mine. Thank you.
Thank you.